number 11, Lease Construction versus Zurich American Insurance Company. Counsel?
Good afternoon. May it please the court. My name is Matt Lodge, and I'm counsel for one of the appellants, Lease US Construction LMB Inc. As I only have 5 minutes, I'm going to jump right into it. So I'm going to talk first about whether the tower crane is covered property. And covered property is something that includes something called temporary works. And so what we're going to do is jump to the definition of temporary works. And the definition of temporary works requires a couple things. From our perspective, we are seeking to prove that the tower crane is a temporary structure. And the specific definition of temporary works includes the phrase temporary buildings or structures. And so we say the
Counsel,
tower crane is...
Could I just ask this before you get into that? Assuming this is a temporary, the crane is a temporary structure, can it also be equipment or machinery?
We don't think it constitutes equipment or machinery for purposes of the exclusion. I think that from a colloquial standpoint, you could call it equipment. You could also call scaffolding equipment. So for example, one of the specific items that's identified as a temporary work in the definition of temporary work is scaffolding. Scaffolding is something that I think, routinely is referred to as quote unquote equipment. And so yes, it could be given that label. It would not be, I don't think it would be especially wrong to do so.
Listen, you only got 5 minutes. The nub of this case in my mind is the question of illusoriness, which gets us to the exclusion. And can you tell me or point me to some place in the record that I should look at that shows that there is or is not remaining coverage on any activities such that it would render the coverage either exclusion on the basis of it's illusory on the basis of the operation exclusion or nearly illusory, as some of the case law has said? In other words, where in the record I go, because it seems to me there's certain things left over, shoring, the form work, scaffolding. There are some things that may or may not be left over, though. I'm not sure about scaffolding. But tell me, what's excluded? What's left after this exclusion operates?
So
let's assume you're covered, okay? Assume you're covered for now. Let's at least say it's a question of fact
right.
as to whether or not you're covered. Get to the exclusion.
What is excluded by the exclusion?
What's your position on the illusory nature of coverage that was in the dissent?
Okay, so I'm not entirely sure I understand your...
What I want to know is the dissent said the coverage was illusory here in the operation. Okay, if it's illusory, that means in my mind that there is nothing left covered as a result of the operation of the exclusion. That's right. Your position, right? No,
there's not nothing. There's a lot of things that are excluded by the exclusion, for sure.
Mm-hmm.
And we claim that the tower crane is not one of those things. So a cement mixer, a drill, a saw, all the run-of-the-mill tools of contractors mm-hmm. are things that would be excluded. I mean, this is something...
Well, why aren't those tools as opposed to equipment or machinery? I mean, we have to assume that those phrases, that those terms mean three different things.
I agree completely. So I mean, one of the points and one of the things that I think illustrates our position is the scaffolding. Scaffolding is one of the things that's specifically mentioned as a temporary work. Scaffolding can be equipment. The exclusion applies to equipment, tools and equipment. And I believe that...
They argue in their brief that scaffolding has never been excluded. That's the way I read it.
I was just going to say that. They agree to that. And what we're saying is we're in the same category as them. The tower crane, the vast majority of it is basically a very large scaffold. It's massive. That's
But isn't it referred to as heavy machinery in your contract with Pinnacle? I mean, how is it not fitting under this if you yourselves have signed off on a contract that calls it machinery?
Because it also qualifies as a temporary work. And the temporary works are not subject to the exclusion.
The
That-
problem, oh, I'm sorry, Judge, go ahead.
Why is it a temporary work?
It's a temporary work because it checks all the boxes. So one of the things that it needs to be, at least from our perspective, our argument is that because it's a temporary structure, that's one of the things. It is included in the total project value.
Okay,
And
Isn't everything
stop you
temporary
there.
that's not the building that you're trying to build? Isn't everything temporary? That's not the building you're trying to build. So what would this provision apply to?
Well, it doesn't refer to the things I mentioned before, the traditional tools. I mean, this is a structure integrated into the building. It's different than the things that typically.
But to be covered under temporary works, it has to be included within total project values. I understand that your argument is that it's included within the cost for superstructure concrete, I guess Pinnacle, and it's not a specific line item, right?
It's under a contract. It's under the Pinnacle contract, and within the Pinnacle contract is the obligation to erect and operate the tower crane.
Cut to the chase, though. It's not listed. Crane, under temporary works at any point, right?
Under the definition of temporary works in the policy, no, it does not list cranes.
So, and you say it's covered in the cost of Pinnacle under the 89 million as superstructure concrete costs. So that's why I asked you, assuming that's, and maybe your co-counsel can raise this issue, because it's the same issue to both of you. When if it's a question of fact as to whether or not that property is covered, and that's why I say assuming it is, then we get to the operation of the exclusion. And when we talk about the operation of the exclusion, my question to everybody today is, what's left after the exclusion operates? What's covered under this policy? That's where I was going with it.
Right, and the tower crane is covered.
I see
It is
that.
not excluded.
Well, I don't know if I agree with the argument, but I see what you're saying. Okay, thank
Yeah.
you.
Thank you, counsel.
Thank you.
Mr. Lambert?
Richard Lambert for Excel, West 57th Street. Every single item in the temporary works coverage provision can be deemed to be contractor's equipment. Okay?
Counsel, could I stop you on there just to follow up on something Judge Fahey was saying about the value? Would it be your position if the crane was completely destroyed in this storm that you would be covered for that cost?
That is correct.
And where, and do you know an approximate value of this crane?
Well, see, the value of the crane, if it got totally destroyed, there's a separate provision in the policy for valuation, which states that the amount of the loss will be determined at the time and the place of the loss, whereas the total project value is determined prior to the issuance of the policy, because it's the estimated construction costs in total. It's a three pages in the record of the estimated construction cost, a laundry list of all of the items, and it's $700 million, and that becomes the amount of the policy prior to the issuance.
But I think a key point here is obviously, is the value of this crane included in total project value? That is obviously a key question here, because if it's in there, I think it has to be a temporary work, because it doesn't fall under any of the other categories of total project value. Wait. So, what I'm wondering is, your loss here is hard to determine from the record what you're claiming. It seems some to the crane, some to the building. But total project value to me, including the crane, would seem to me to cover, maybe this isn't relevant, but seem to cover the loss of the use of the crane or getting it back into operation. And how would you then cover, let's say, I don't know, I have no idea how much this crane is worth to replace. But your view would be that that value, a replacement value for this crane, is covered in total project value.
No. Total project value is the estimated construction cost for the project. So the value of the tower crane, where the construction cost of the tower crane included in the total project value, the total project construction cost. And it is because the construction cost for the crane, which involved the engineering design, the providing of all the parts and materials, the labor to erect it, and the labor to disassemble it, were all included in the $80 million Pinnacle contract, which is a package deal.
But to follow up on Judge Garcia's question, then if there is if you're making a claim, then why isn't that limited to loss of use versus if you had included the entire value of the claim, of the crane itself, then if the crane itself was destroyed, then you'd have coverage of the crane.
No, there was no requirement to put the replacement value of the crane
Why would
into...
an insurance company have a policy that way? So, I mean, I have no idea what this crane
It
is
covers
worth, but let's say it's worth hundreds of millions of dollars, okay? Why would they cover its total loss if that wasn't included in the,
It's included in the total project value, which are the construction costs for the project. For instance, the Pinnacle contract is an $80 million contract. It includes all kinds of temporary works. It includes scaffolding. It includes form work. It includes 2-tower cranes.
But do you put in the value of the scaffolding or just the cost to erect it and bring it there and take it down when you're done? Which is it? That's the question.
Well, all of that, all of these temporary works are covered because the construction costs for this work, scaffolding, form work, tower crane, were all included in the $80 million.
Who owns the crane, counsel? Is it Pinnacle, or do you own the crane? Who owns the crane?
The crane is owned by someone that it was leased from.
Yeah, I thought you leased it for $79,000 a month or something.
Well, that was, you know, the tower crane, that was a part of the tower crane that sits on the top. But the temporary works coverage provision doesn't say rented scaffolding, owned scaffolding, leased scaffolding. Okay, you are reading that into the temporary works coverage provision. Scaffolding is covered whether it's rented, owned, borrowed, or stolen.
My question to your co-counsel, and just to follow up on the other judges' questions, is the same. Assuming that it's a question of fact as to whether or not the crane was covered property and included within the total project value, it is not explicit. You can argue, I think a reasonable argument could be made that it's a question of fact. So let's assume it is. So then we go to the question of the exclusion, and has the exclusion created an illusory contract by virtue of the fact that it would eliminate everything that's supposedly covered? In other words, you would have no benefit of your bargain.
Well, it would...
And your response when you first came up was that everything there could be characterized as a tool, so therefore it's illusory.
So the temporary work coverage provision would be illusory because the exclusion provision would swallow that entire temporary works coverage.
So your position is the form work wasn't covered, the shoring wasn't covered, none of the scaffolding costs or erection or anything were
all
covered?
covered in the temporary works provision, and it's specifically covered in the temporary works provision.
I understand that. That's not my question, though. My question is, by operation of the exclusion, was that coverage lost, or were those things, in your mind, still covered?
The exclusion provision does not apply to those temporary
So
works.
they were still covered?
Yes,
Okay.
because the exclusion provision, if you apply it to all of those temporary works items, because they all can be deemed contractor's equipment, would render the temporary works provision of no force and effect because all of them would be excluded. And at page 49 of defendant insurer's brief, they acknowledge the fact that all of the items in the temporary works provision are not subject to the exclusion provision, except for temporary structures, which makes no sense.
I see.
Thank you, counsel. Counsel?
Thank you, Your Honors. Philip Silverberg for the respondents. I'd like to just, obviously, of course, address all of your questions. I'd like to address a couple of comments that were made by...
Is your position, what he just said, that temporary structures are excluded?
Well, let's look at the provision temporary works. And the policy defines what's a temporary works, and it talks about
Is it yes or no? And then you can...
The answer is temporary buildings or structures, including office and job site trailers, all incidental to the
But
project.
assuming that we were to find that this crane fits within that coverage provision, or at least that there's a question of fact to that, just assume that for a moment.
Yes.
Okay. Then tell us what you think the exclusion provision does to that coverage provision.
The exclusion provision, and this is basically, you know, fundamental insurance and contract case law, the exclusion takes away it's an exclusion, takes away certain things that are granted in the coverage.
Does it take away all of those things listed in the temporary work, scaffolding and fencing and all of those things?
No, it does not,
Why?
provided that it meets the criteria of what is a temporary works. And I recognize your question is conditioned on my assuming
Yes.
that the crane, that this 750-foot
We're
crane,
trying to determine if there's any distinction between those items, assuming they're all part of temporary works, and if there's anything left to any of those after the temporary work.
yes, there is, and you even,
After the exclusion.
and you even heard an answer from counsel. He talked about cement mixers, he talked about tools, he talked about all these other things.
But that's, of the items that were listed under the temporary works, is anything left after the exclusion operates?
Yes,
What?
cement mixers, tools,
But the exclusion
equipment.
says tools.
What?
The exclusion says tools.
No, he.
Why isn't a cement mixer machinery?
No,
Why isn't it
I think-
equipment?
I think it is machinery, but if you go back to the temporary works provision, it enumerates very specific things. It talks about scaffolding, it talks about formwork, and then it talks about office and job site trailers.
I
and
thought your argument was that because scaffolding and those other things were specifically listed.
That's exactly right.
They don't fall within the exclusion, but because that provision doesn't say crane, that does fall within the exclusion.
That's correct,
That
and I'm
your
sorry if I misstated it. And the only comment about temporary buildings and structures in the temporary works definition says including office and job site trailers, all incidental. So the
So I'm
including.
sorry, so then your position is if something, let's just use the word thing now, excuse me for the moment, is a temporary structure and machinery, it's excluded. Is that a yes or a no? That's all it takes here.
I would say that's a yes.
Okay, so then, your position is, though, that there are other things that don't fit under the exclusion that are temporary structures, that may not already be listed, correct?
That's correct.
Okay.
Yes, that's correct, and I believe that, at least I hope that's what came across in our briefing. Now,
So we're not leaving this point yet.
Sure.
So scaffolding, shoring, formwork, false work, those are all still covered under your interpretation of the contract, even after the exclusion operates?
yes, Your Honor.
Okay.
Yes, they are,
So
provided
you
that they.
disagree with your adversary that all of those things that are listed under temporary works could also be considered equipment?
I don't think that they would be considered equipment, but again, the point is that these are specifically enumerated in the temporary works provision definition. It defines what is a temporary work, which also includes office and job site trailers and items of that ilk. This crane is something very, very different, and there's a couple of points I'd like to make. There are a lot of questions about the value of the crane itself, and even the dissent, which went out of its way to say, you know, they disagreed with the insurers here, and we disagree with that part of the dissent. But what the dissent did say is we would not grant summary judgment because we have to know if the value of the crane itself was in the policy, because as it says in the temporary works provision, total project value. We haven't gotten a straight answer. What I can say is the value of the crane itself is not listed. It's not part of the project value. Yes, there's a $77,000 a month lease. Yes, there may have been labor costs to erect this crane. The value of the crane itself, it's owned by a third party, it's leased to a subcontractor who then works on the project.
If they're not seeking a claim for the value of the crane itself, their claim is for the loss of use, maybe some damage that prevented it from using the crane for a period of time, delay in the project, all that. If that's their claim, why wouldn't that be covered if those costs are included in the contract?
Because this is the first-party property policy. We insure the property itself. This piece of property is not insured under this policy. It is insured under another policy. It's not insured under this policy.
Piece of property being the crane?
The crane is the piece of property that's not insured here. We say it's not insured. It's
Pinnacle has insurance on the crane.
yes. Now, also, I think it's worth noting, and we mentioned in our briefing, that the insured, Extel, did have an opportunity to endorse onto this policy the tower crane, and that endorsement is record 825, 826. It's blank. They didn't list it. If this was such an important part of the project that they wanted to insure, they could have chosen to insure it. They did not. There was also, I think, a very early question about whether or not the tower crane was equipment. And while we pointed out in our brief, and just the record site would be 602, the crane is referred to as equipment in the sublease itself. There's no question that this crane is a massive piece of equipment. Going back, and I recognize that some of the questions here today have asked me to assume that it is a temporary works. I don't think a fair reading of this entire contract gets you to find that this crane falls within the definition of temporary works. When you look at what's listed, and when you look at what modifies buildings or structures, comma, including office and job site trailers, this crane is nothing like that. And it's well documented in the record and in the briefing. It's 750 feet. They had to build a platform for it. This is a massive structure. This is not the type of item, short of a separate endorsement, where it would be insured under under this type of builder's risk policy. Also, one of the things where I think was really...
Just to clarify, are
Sure.
the items that are specifically listed, scaffolding, so forth, excuse my ignorance, are any of them attached to the building you're trying to build, or that they're trying to build?
I believe temporarily they would be, sure.
Physically attached, and could not work but for being attached, or would not be used but for being attached? Like the crane, right? The crane's got to be attached.
It's not, I get, sure, if someone wants to say attached in one form or another, and I'm not quite a construction expert, although I dabble in it a little bit in my legal life. For the most part, certainly not attached where this was built into the building at some point, and then, of course, taken out and unassembled. I'm talking about the crane itself. Whether or not scaffolding is physically attached for a part of the time while the building's going up, it may be. I don't specifically know the answer to that question. But I will say in the dissent, essentially, the phrase "all incidental to the project," and we say that the crane is something very different than scaffolding, very different than a job site trailer or any of these other items. It was not just incidental, and I know that there's a lot of back and forth between the majority and the dissent on this, but to accept the dissent's treatment of that phrase is essentially to wipe that phrase out, because essentially everything that's temporary would not be incidental. They're reading that phrase out of it, and they basically create a superfluous term here. That's not what the majority did, and that's certainly black letter of contract
You say
construction.
incidental only applies to this temporary buildings or structures?
Right, and it would not apply.
So
In
what's
other
the
words, the
point of the
crane
wo-
is not something
Yes.
incidental.
What's the point of the word "all," as opposed to saying "which are," "that are"?
Because I believe it modifies including office and job site trailers, all
I'm saying,
incidental.
but why, wouldn't it be clear to have said "that are," "which are"? Doesn't "all" suggest that perhaps it applies and modifies more than what you say it does?
But then, what would be the purpose of that phrase at all if everything that's not a permanent part of the project becomes a temporary work? Everything, and that would render that a superfluous term. And I believe that was the point of the majority. I know it's my point here, and I believe that's where the dissent got it wrong.
Thank you, counsel.
Thank you.